Welcome back to Ask a Lawyer. Let's listen in as attorneys Mark Avera and Jack Bove discuss trusts and what having one might mean to you.
Jack, from time to time when we resolve cases on behalf of clients, they ask us whether they should consider some type of trust with the assets that they now have. And I never know what to tell them and seek help to answer that question for them. Who should consider setting up some type of trust?
I'm a big proponent of trusts for those who really want to control the assets from the grave, if I may use that phrase. I liken a trust to a treasure chest. And I'm going to put my wealth into that treasure chest, and then I'm going to leave behind instructions in the form of a trust agreement. And I'm going to tell the trustee, who might be my financial advisor, might be my banker, might be my trusted lawyer, to follow these instructions and to dole out my treasure to my beneficiaries, perhaps my children, friends, charities, according to those instructions that I've left behind. And I think it's a great way to manage wealth into the future. A lot of times folks have children who are minors, or perhaps children who spend too much and aren't ready to manage the money themselves, and trusts are a great tool in those cases.
Are there tax advantages to setting up a trust that go into effect once you pass on?
There can be. Depending on the kind of trust, it may be exempt from estate tax when the beneficiary passes away. And when we think about the estate tax being a flat 45%, it is certainly something to be avoided.
Now, our firm is involved in time to time in trust litigation where there are disputes between a beneficiary of a trust and the trustee of a trust. Some of those trusts are in existence before somebody dies. What kinds of trusts come into effect before somebody dies?
Well, trusts fall into a number of categories. Probably the two largest categories would be revocable, meaning I can put assets into that treasure chest, but I can change my mind later. Or they can be irrevocable, meaning I put the assets in the treasure chest, but once I've made that gift, I cannot take it back. And the litigation that you're referring to that we work on together sometimes has to do with irrevocable trust, where I've already made the gift and I wrote what I thought the rules ought to be, but perhaps the beneficiary doesn't agree with the rules or doesn't agree with the way the trustee is administering the rules.
What would be the benefits if somebody wants to set up a trust before they die? What would be the benefits of using a revocable trust as opposed to setting up an irrevocable trust?
The largest advantage of the revocable trust is the ability to avoid probate. And the advantage of the irrevocable trust typically is to get those assets out of my estate in order to avoid estate tax at my death.
And can someone, if they sit down and do some estate planning, which I guess means talking about wills and trusts, can somebody set up trusts at the same time they're doing their will?
Absolutely.
Can these things be changed over time, wills or trusts?
The will can be, and the revocable trust can also be changed. The irrevocable trust is difficult to change. It can be changed, but it's a more difficult process.
What type of trust do people usually have that go into effect once they pass away?
They can either create typically it's a trust that's created under their will, or it's the revocable trust that now that I've passed away becomes irrevocable. But in either case, I'm leaving a set of instructions for the trustee to follow to dole out my assets to my loved ones.
What would be involved if somebody wanted to talk to someone about setting up a trust or to actually set one up? What's involved in that?
Clients, I like clients to come into my office with a general form of a personal financial statement. Tell me generally what you have and what it's worth, and then have a real good idea of where you want those assets to go after you pass away. Probably the classic example of someone who would want a trust would be that if husband has a child from a prior marriage and then remarries, and husband wants to take care of surviving wife as long as she's alive, but at her death she wants the remaining assets to go back to the son from the prior marriage, and a trust is tailor-made for that situation.
You run across lots of situations where folks pass on and don't have these kind of vehicles in place.
Unfortunately.
Does it make it easier for estate planning purposes or to, I guess, probate an estate to have these kinds of planning vehicles in place for lawyers to come and assist with wrapping everything up?
Yes, streamlines the process, and the assets go where the client intended them to go.
Would it be accurate to say that the more assets you have, the more complicated the trust issues are? Or is that not necessarily true?
Typically, but not necessarily. Probably more dependent on the fact pattern. If I have children from several marriages, then the facts get more complicated regardless of the level of wealth.
Jax, thanks for your time today. It's been valuable insights.
You're welcome.